Now I am going to dictate a legal passage at the rate of 160 words per minute based on Jharkhand High Court latest judgment. Let's start. This criminal miscellaneous petition has been filed invoking the jurisdiction of this court under section 482 CRPC with a prayer to quash the entire criminal proceeding in connection with Bank Board PS case number 136 of 2020 registered under section 323, 341, 342, 384, 385, 386, 387, 506, 34 of the Indian Penal Code para. The learned counsel for the petitioner and the learned counsel for the opposite party number 2 jointly drawing attention of this court to the interlocutory application number 3591 of 2022, which is supported by separate affidavits of the petitioner and the opposite party number 2 submits that therein it has been mentioned that a compromise has been effected between the parties and the parties have amicably settled their dispute outside the court in the interest of long-standing peace and harmony between the parties, and after the compromise normal and healthy relationship has been restored between the parties, it is next submitted that the dispute between the parties is basically a private dispute and no public policy is involved in this case, and as the compromise has entered into between the parties, the chances of conviction of the petitioner is remote and bleak. Hence, it is submitted that the continuation of a criminal proceeding would amount to abuse of process of law. Therefore, it is submitted that the entire criminal proceeding in connection with the Bank Board PS case number 136 of 2020 registered under section 323 or 341, 342, 384, 385, 386, 387, 506, 34 of the Indian Penal Code to be quashed and set aside para. The learned special PP submits that the state has no objection to the prayer for quashing the entire criminal proceeding in connection with the Bank Board PS case number 136 of 2020 registered under section 323, 341, 342, 384, 385, 386, 387, 506, 34 of the Indian Penal Code in view of the compromise between the parties para. Having heard the submissions made at the bar and after going through the materials in the record, it is pertinent to mention here that the Honorable Supreme Court of India in the case of Prabhavati Ahir versus State of Gujarat reported in within the 2017 9 SCC 641 had the occasion to consider the jurisdiction of the High Court under section 482 of Code of Criminal Procedure inter alia on the basis of compromise between the parties, and has held in paragraph number 11 as under para. Section 482 is prefaced with an overriding provision. The statute says that the inherent power of the High Court as a superior court to make such orders as are necessary within bracket small I to prevent an abuse of the process of any court, or within bracket small I otherwise to secure the ends of justice in Gansing within bracket Gansing versus State of Punjab. A bench of 3 learned judges of this court adverted to the body of precedent on the subject and laid down guiding principles which the High Court should consider in determining as to whether to quash an FIR or complaint in the exercise of the inherent jurisdiction. The consideration which must weigh with the High Court are within bracket ACCPP dot 34243 para 61 the power of the High Court in quashing a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under section 320 of the court. Inherent power is of wide longitude with no statutory limitation, but it has to exercise it in accord with the guideline engrafted in such power viz within bracket 1 to secure the ends of justice, or within bracket small ii to prevent the abuse of the process of any court in what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offender and the victim have settled their dispute would depend on the facts and circumstances of each case, and no category can be prescribed. Stop. Thank you.